Thank you very much for the opportunity to speak with you today. I realize that I'm the last speaker before lunch, and I appreciate my precarious position. My topic is the Charter of Rights and its impact on the law of evidence in criminal cases, and perhaps we ought to make clear at the outset what it is we're talking about, because it's rather complicated. But what happened, as you know, is that there's a United Kingdom statute called the Canada Act, and that has a schedule. And that schedule is called the Constitution Act of 1982. And that Constitution Act of 1982, in turn, has a part. And Part 1 of that has a schedule. And Schedule B of that part, this sounds like one of my children's books, is called the Canadian Charter of Rights and Freedoms. So ultimately, we arrive at this relatively short document, which is probably the best thing that has happened to the legal profession since Britain gave up Hong Kong. It has already produced, since its proclamation 2 years ago, it has already produced close to, by actual count, 800 judgments of all levels of courts. These aren't the decisions that are dismissed without written reasons. This is 800 judgments. So on behalf of myself and my estate and my children, I thank those who made this part of the law. If they proclaim the Uniform Evidence Code, then my great-grandchildren will be looked after as well. Now, undoubtedly, initially there was a certain judicial negativism towards the charter arguments that were raised, because there was a fear that we were simply reading too much American case law. But I think it's fair to say that in the last year, there's an undoubted judicial sensitivity to and appreciation for the new era in constitutional interpretation under the Charter. And I think it's also fair to say that as a result of certain decisions I'll refer to, such as those of Justice Martin, who has looked very closely at American case law, there is no longer this automatic aversion to American case law. And what I propose to do is go through the sections of the Charter that may impact on the law of evidence and highlight some of the issues that have arisen and undoubtedly will arise under the respective sections. And the first section is Section 7. And it's essentially called Life, Liberty, and Security of the Person. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. This, in effect, is the Due Process Clause in the Charter. And one important issue is whether it's limited to procedural considerations or whether it embraces substantive considerations. That's not that important for the law of evidence. So for our purposes, I would take as a definition of this section what our Court of Appeal said in Regina versus Potma, in which the court pointed out that terms like fundamental justice, natural justice, or fair play, it's a compendious expression intended to guarantee the basic right of citizens in a free and democratic society to a fair procedure. The principles or standards of fairness essential to the attainment of fundamental justice are in no sense static and will continue, as they have in the past, to evolve and develop in response to society's changing perception of what is arbitrary, unfair, or unjust. So you see the breadth of this section. This section can be appealed to any time you wish to make the argument that what's taking place is unfair or unjust, such as the introduction of hearsay evidence or some old newspaper article from 60 years ago. I don't mean that facetiously. I'm serious. Anytime there's an appeal to justice, Section 7 of the Charter can be pointed to. That's why it's sort of hard to define with exactitude its scope, but I can give you a few examples. Potma itself held that the failure to provide an accused with breathalyzer ampules for independent testing on drinking and driving charges does not violate Section 7. There is a law review article that remains to be written someday as to why Canadian civil liberties have consistently been defined in the context of impaired driving charges. But I haven't had the time to write it yet. But in any event, issues of Crown disclosure exemplified by Potma will undoubtedly continue to be measured under Section 7. And there have been other cases, another case where our Court of Appeal held that the failure to order production of certain evidence at a preliminary hearing in obiter was held not to offend any principle of fundamental justice. Now, the reason disclosure is important is that one of the fundamental due process doctrines in the United States deals with disclosure and discovery requirements based on the famous 1963 case of Brady versus Maryland, which held that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the poor faith or bad faith of the prosecution. So the questions of discovery or disclosure is one area where Section 7 will undoubtedly impact on the law of evidence. Certain specific evidentiary matters have been tested under Section 7. For example, the use of transcripts or the dispensing with viva voce evidence, such as under Section 643 of the Criminal Code, if a witness is absent from Canada or has died or is ill, the Crown is entitled to read in the transcript of the preliminary hearing. And that was attacked under Section 7, and in two cases it was held that it is not a violation of Section 7 to utilize Section 643 of the Criminal Code. In extradition matters, as I'm sure you're aware, viva voce evidence is not the norm, rather matters proceed by way of affidavit or depositions. And again, this was quite early on attacked as being a violation of Section 7. In other words, to be sent to a foreign country based upon something written on a piece of paper denies fundamental fairness. Courts split on this. The lower court split on this. There were decisions both ways, but recently, January 27, 1984, our Court of Appeal, in two separate but related judgments, upheld the validity of such provisions in extradition practice. So the attack under Section 7 failed. I mentioned presumptions at this point only in passing. As you know, one of the common devices in the law of evidence is certain presumptions or inference which allows a party to prove fact A and thereby establish fact B without more. These have been attacked under Section 7 to some extent, but their successful attack has been under another section that I'll deal with later, and so I just mentioned them in passing. Given the breadth of Section 7, its impact in the future on the law of criminal evidence will be limited only by the ingenuity of counsel. For example, in the United States, even eyewitness identification by means of a lineup or otherwise has developed constitutional dimensions. The American Supreme Court holding that due process forbids a lineup that is unnecessarily suggestive and conducive to irreparable mistaken identification. So you see, lots of things in the law of evidence can be characterized as fundamentally unfair and thereby attain constitutional dimension. Now, I'd like to move on to Section 8, search or seizure. This is, in my view, the single most important section of the Charter as far as criminal law is concerned, and as far as criminal evidence is concerned as well. Excuse me, I'll be right back. Try it that way. Every criminal case involves a search or seizure by the police. Virtually all criminal evidence is derived from a search or seizure by the police. And one of the hardest things for counsel to get their heads around since the proclamation of the Charter is to test all of the incoming evidence in a criminal case against Section 8. Section 8 provides everyone has the right to be secure against unreasonable search or seizure. This section is without predecessor in the Canadian Bill of Rights, and it should be noted that the original Charter version omitted any requirement of reasonableness. It simply required that a search or seizure be authorized by law. The wording was undoubtedly changed to bring it in line with the American Fourth Amendment. And undoubtedly the American Fourth Amendment is the source of this section. Now, that section provides as follows: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, first of all, does our guarantee cover the same ground as the American guarantee? You see that the American guarantee goes on and says secure in their persons, houses, papers, and effects. Well, I would suggest that it does. Our section is written in a more economical, elliptical style, simply because the rather archaic American language pretty well lists every respect in which the people are to be secure. In other words, since the list is exhaustive, it's unnecessary to include it at all. As well, it strikes me as kind of ludicrous to argue that our Section 8 was only intended to adopt some of the respects in which the people are to be secure, not the others. In other words, it's kind of hard to read into Section 8 a right to be secure in your person but not your property, or vice versa, to be secure in your property and not your person. What possible justification is there for reading that distinction into Section 8? The right is to be secure, period, against unreasonable search or seizure. That, I would suggest, would include a search or seizure of your property, your person, your private communications. I'll come back to that. So I think the Fourth Amendment and Section 8 cover the same ground. Secondly, as to what is a search or seizure, this is a very, very important issue. Until 1967, the Americans used the obvious concept, namely that of property. If the police took something that was yours, then there had been a search or seizure under the Fourth Amendment. In 1967, they switched to a new concept, which I suggest will probably be adopted in Canada because it's so reasonable and sensible and modern, and that's the privacy test, that there is a police intrusion whenever the police violate a, quote, reasonable expectation of privacy. So whenever the police take something from you that violates a reasonable expectation of privacy, then there is a government intrusion that has to be measured against the Fourth Amendment or Section 8 of the Charter in Canada. The next point is this: the Fourth Amendment is a bit longer and effectively breaks down into two clauses. The first is called the Reasonableness Clause, the right of the people to be secure against unreasonable searches and seizures shall not be violated. That clearly has been brought into Canada. And this Reasonableness Clause is the source of many Fourth Amendment doctrines. However, there's a second clause in the Fourth Amendment that's absent from Section 8 of the Charter, and it is called the Warrants Clause. No warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, this warrant clause does not govern the question of when a warrant is essential to satisfy the Fourth Amendment. That is an issue of reasonableness. The warrant clause merely specifies certain requirements if and when a warrant is utilized, and those requirements are probable cause, oath, and specificity. Now, I would suggest that although the Charter, as compared to the Fourth Amendment, adopts only the Reasonableness Clause and not the Warrant Clause, the net effect of the provisions is the same for three reasons. First of all, our common warrants clause in criminal law, the Criminal Code, Section 443 and following, already meets the warrants clause of the American Fourth Amendment. It requires evidence under oath and specificity. So therefore, the drafters of our charter would have felt it unnecessary to incorporate the warrants clause into a modern charter because we already, as a general principle, recognized what it was designed to obtain. Secondly, it's arguable that the warrant clause is only a particular example of reasonableness in the particular context of search warrants, so that the warrant clause is effectively already covered by the reasonableness guarantee. that is, a search warrant issued without reasonable cause or oath or without particularity, is in and of itself unreasonable. And then finally, the arguments can be combined to say that the code section set the standard of reasonableness for search and seizures under warrant, and therefore the Warrant Clause is in effect entrenched as part of the reasonableness guarantee. Now, the other single most important principle to be developed under Section 8, and all else hinges on this. Unless our courts accept this, then Section 8 may become not live up to what it could be. And that's this, that in the United States there is a fundamental principle of Fourth Amendment law that there is a judicial preference for searches with a warrant. The American Supreme Court has frequently interpreted the reasonableness clause so as to make searches under warrants the rule and warrantless searches the exception. In other words, searches conducted outside the judicial process without prior judicial approval are per se unreasonable under the Fourth Amendment, subject only to a few specially established and well-delineated exceptions. Now, I'm happy to say that in a case that I'll refer to shortly called Southam Incorporated, and strangely enough, Southam, I think, has now figured in 3 charter cases, so we owe a great deal to that news chain. Southam Incorporated versus Combine's Investigation Branch. In that case, I suggest that the Alberta Court of Appeal seems clearly to have established this preference as part of our law under Section 8. And of course, this is ever so important because in every criminal case, there will be searches or seizures without warrant. Warrants are numerically the exception for searches or seizures by the police. So every criminal case virtually will involve a Section 8 issue. What are the common law, or what are the exceptions authorizing warrantless searches? I'll just list them quickly. Some of these have started to appear in our law. There's what's called the Plainview Exception. This was expressly adopted by our Court of Appeal in February of 1983. Articles which are in plain view may be seized by an officer lawfully on the premises and may be produced in evidence. Another doctrine is search incident to arrest, where you lawfully arrest a person, the law permits a search incident to that arrest. The scope of that search and whether and how far it extends beyond the person to the surrounding vicinity is unclear and undoubtedly will be litigated. A consent search, and the meaning of consent in this context, an accused can always consent to the police searching for something if he chooses. You're obviously going to raise issues of voluntariness in that context. Other doctrines in the United States that have yet to surface in Canadian law are emergency searches in exigent circumstances, searches of vehicles, because vehicles are viewed as being exceptional cases. They can drive off while the officer is running off to get a warrant. So special doctrines have been developed for searches of motor vehicles stopped on the highway. Searches and seizures in open fields. If you're growing your marijuana without a fence around and a plane flies over, you can't really complain if the police note the marijuana there. And seizures of abandoned property. And this is a delightful issue that I can hardly wait to litigate in Canada, where a criminal throws out his garbage. Do the police need a warrant to go through the garbage? And of course, the arguments on the one hand are the criminal isn't throwing out his garbage for the police, but for the garbage man. So he's throwing it out for a very specific purpose. He hasn't abandoned it totally. Until the law is settled, I advise all my clients to watch their garbage. Now, Section 8, turning from warrantless searches, Section 8 will have an impact on statutory provisions authorizing either warrantless searches or searches with warrants failing to meet the standards of Section 443. 2 important examples that are in the process of being litigated: writs of assistance, which Canada wants to cling to for some reason unofficially. That's being litigated, whether they violate the Charter. And disorderly house warrants. This is a historical relic that has, but it's come into prominence in Toronto recently in the drive to clean up prostitution. It doesn't require an oath for no other reason than simply historical accident. So those warrants obviously will be attacked as violating the Charter. Now, the important case that I mentioned, Southam Inc. versus Combine's Investigation Branch, it dealt with provisions section 10.1 and 3 of the Combine's Investigation Act. It allowed a search and seizure of evidence by the director, but it did not meet the requirements of section 443 of the Criminal Code. In other words, it did not interpose an independent judicial officer between the searcher and the citizen to ensure that the search was undertaken only on proper grounds established on oath. For that reason, the Alberta Court of Appeal held the sections violate Section 8 of the Charter. The matter has gone on to the Supreme Court of Canada. That case clearly indicates that the American model for a warrant is also our model under Section 8 of the Charter. A couple of other issues that have yet to arise. Pretext searches is another American doctrine. It arises again in our context, drinking and driving. It is arguable that random stops without legislative authority, where an officer is merely pretending to use some statutory power, such as checking for licenses or insurance, but he's really looking for impaired drivers, are merely pretext searches and violate Section 8 of the Charter. It's the American authority that such searches violate the Fourth Amendment. A random license check, to get closer to home in Ontario, absent reasonable suspicion of unlawful conduct, is an unreasonable seizure, according to a leading case of Delaware versus Prowse, American Supreme Court, 1979. Now, this case was distinguished by our Court of Appeal in Dedmon, which allowed stops by officers, the RIDE program. Those of you who've been stopped by it and have been released on bail and are here with us today. But so our Court of Appeal distinguished that because of the American Fourth Amendment. Well, that distinction obviously no longer applies after Section 8 of the Charter, so that the question now is, does the RIDE program survive Section 8 of the Charter? The RIDE program was subsequently given legislative approval in Ontario by a new Section 189 small a added to the Highway Traffic Act. Obviously, the validity of this section has to be now measured against Section 8 of the Charter. Undoubtedly, Section 8 has had an impact in criminal cases. A number of cases have had evidence excluded because of it. Just to take one example that I always like because it strikes so close to the hearts of policemen, large-scale random searches of the audience at a rock concert. I mean, I've never understood the logic of that, and courts have held you can't do that, and it's a small blow for rock musicians. Electronic interceptions constitute a government seizure. It's important to bear this in mind, and it specifically impacts on one very important issue that is before the Supreme Court of Canada now, and that's the right of the police to trespass to plant an intercepting device. Under the wiretap law, the courts have held that a judge can't authorize the police to break into your house to plant the listening device. And courts have also held that if the police do that, it's illegal. It's against the law. They haven't quite specified in what respect, but they've said it's illegal. But they've also said it doesn't matter, because the only way you can keep the evidence out is if the interception was illegal. And they said the illegality in planting the bugging device wasn't part of the legality of the interception. So therefore, you didn't get automatic exclusion under Part 4.1 of the Criminal Code on the basis the interception was illegal. What's important is that once you realize that the interception of communications is a search or seizure, therefore the illegality in breaking in now violates Section 8 of the Charter, so that while you can't get automatic exclusion under Part 4.1 of the Code, you can argue for discretionary exclusion under the Charter of Rights. And in view of the fact that the police have been consistently told it's illegal, it seems to me you'd have a very good argument for exclusion under the Charter of Rights remedy that I'll refer to shortly. The next section that impacts on the law of evidence is Section 10b, the right to counsel. And here again, we've learned from the Americans Prior to the Charter of Rights, if the police denied you your right to counsel, it didn't matter. That may be astonishing for you to believe, but that was the law. It didn't matter. Even if your counsel was at the police station door begging to see you, and the police kept him from seeing you, and even if you had the check there ready to retain him, and it was certified so that there are no problems, and the police prevented that, it didn't matter. If the statement was voluntary, it went in. The Americans, in the famous cases of Escobedo and Miranda, said, you know, if you're going to give a man a right to something, you've got to give him a remedy. Otherwise, it's just hypocrisy. And so based on the Sixth Amendment assistance of counsel guarantee and the Fifth Amendment self-incrimination guarantee, they said that when a man's in the police station and he says, I want to talk to a lawyer, all questioning must stop. Prior to that, you must go through a litany that informs him of his rights, and then once he chooses to exercise that right, all questioning must stop. Well, I'm delighted to say that in a recent decision, November 28, 1983, called Manninen, M-A-N-N-I-N-E-N, Associate Chief Justice McKinnon for our Court of Appeal seems to have held to the same effect, that under Canadian law now, under the Charter, once a man says, I want to talk to a lawyer, the police cannot thereafter initiate any further questioning of the suspect. What the accused said in Manninen was, prove it. I ain't saying nothing until I see my lawyer. I want to see my lawyer. The police, with their usual respect for the right to counsel, then said, what's your name, what's your address, and where's the knife that you used to hold up the Max Milk store? And Justice McKinnon just tore a strip off the police that was a pleasure to read. Quite frankly, it's on the appellant's claiming his right to remain silent and to see his lawyer under the circumstances recited, the constable should have offered him the use of the telephone so that he might exercise his right. His answers to the questions, when he could have remained silent, were not in any sense, in my view, a waiver of his right to consult his lawyer without delay. The conduct of the police officers was such as to render the reading to the appellant of his charter rights a mere ritual without significance or meaning. And he then went on to apply the remedy section, section 24.2, to exclude the confession, and I'll come back to that when I deal with that section. Again, his words are music to the ears of any defense counsel. The next important section, because this one deals with presumptions and inferences, is section 11D of the Charter. Any person charged with an offense has the right, D, to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. Now, the important point here is the right to be presumed innocent until proven guilty according to law. And here, there are two important decisions, both written by Justice Martin of the Court of Appeal, that again, to a large extent, have looked at American due process analysis, but have rewritten the law of evidence as far as presumptions go. And the two contexts in which they arose are as follows. The first one dealt with Section 8 of the Narcotic Control Act. Those of you who have been found with large quantities of narcotic drugs are familiar that Section 8 provided you with the two-stage trial, where first the Crown had to prove you were in possession, and then you were allowed to disprove that you had it for the purpose of trafficking. And trafficking essentially meant anything other than using it all yourself. And this section was attacked as being unfair to the accused on many occasions, and then ultimately in the case of Regina versus Oakes, and again it's gone on to the Supreme Court of Canada, but in the Oakes case, our Court of Appeal, speaking through Justice Martin, laid down the following as the law concerning the validity of presumptions measured against the Charter of Rights. They said, first of all, we recognize that it's a common device for the legislature to impose a reverse onus. And in theory, there's nothing wrong with that. However, the threshold question in determining the legitimacy of a particular reverse onus provision is whether the reverse onus clause is justifiable in the sense that it is reasonable for Parliament to place the burden of proof on the accused in relation to an ingredient of the offense in question. So that's a threshold question. Was it reasonable for Parliament to do what it did? And there are three factors listed speaking to that issue. One, the magnitude of the evil sought to be suppressed, the difficulty of the prosecution making proof of the presumed fact, and the relative ease with which the accused may prove or disprove the presumed fact. So that's he went on and said, manifestly, a reverse onus provision placing the burden of proof on the accused with respect to a fact which is not rationally open to him to prove or disprove cannot be justified. So anything which made an accused prove or disprove something that he really didn't have a chance to do, that falls at the threshold. That doesn't even get off the ground. But assuming that the presumption is reasonable, a reverse onus provision, even if otherwise justifiable by these criteria, cannot be justified in the absence of a rational connection between the proved fact and the presumed fact. In the absence of such connection, the presumption is purely arbitrary. So even if it's reasonable for Parliament to make the accused prove it, the next question is the presumption arbitrary, or is there a rational connection between the proved fact and the presumed fact? And here is where our law is even better than the American law. Whether intentionally or not, I don't know. But I don't believe the American cases went quite this far, but Oakes says that the test for a rational connection is the following. A rational connection between the proved fact and the presumed fact exists where the proved fact raises a probability that the presumed fact exists. So that a presumption to survive, there must be a probability that if you prove the proved fact, the presumed fact will exist. A number of other courts of appeal fell into line with Oakes, and everyone now universally agrees that Section 8 violates the Charter. The other important decision from our Court of Appeal is Boyle, B-O-Y-L-E. And in this case, the court was dealing with the reverse onus section 312 sub 2 of the Criminal Code, dealing with obliterated serial numbers. And this is where if you have auto parts and the serial numbers are obliterated, the Criminal Code presumes certain things from that. And the two presumptions are as following. On a charge of possession of stolen property, where the serial numbers are obliterated, two presumptions are drawn against the accused. One, that the vehicle or part thereof was obtained by the commission of an offense, and two, that the accused knew the vehicle or part thereof was obtained by the commission of the offense. So one presumption identifies part of what the Crown must prove, that in fact it was stolen. The second one is a presumption of guilty knowledge. And the court, first of all, distinguished between the two presumptions and said that while the first one is valid, that if the serial number is obliterated, we think it's reasonable and it follows by way of probability that it's been stolen or obtained by a crime. We have no trouble with that. We have trouble with the second one, and they struck down the second presumption. Why? Because they measured it against the so-called doctrine of recent possession, which says it's just a matter of common sense. If you're in possession of the Hope Diamond, which was stolen last month from a museum in England, there's a pretty good inference that you're the thief, because just not that many people get the Hope Diamond in the course of a month. But what's crucial to that presumption is that it's recently stolen. If you're in possession of a bicycle that was stolen 3 years ago in Calgary, there's no inference that you're the thief or that you knew it was stolen, because that kind of object can, change owners in a year or two quite easily. So what's important to the doctrine of recent possession is recency. There's got to be some time limit, at which point the inference becomes too weak to be drawn. What was wrong with this presumption is there was no time limit. Once those serial numbers were obliterated, it doesn't matter if it was stolen 10 years before. The Crown was still entitled to infer that you knew it was stolen even 10 years after the event. So Justice Martin said, that doesn't follow as a matter of probability, therefore that presumption violates the Charter. No other of the reverse onus clauses have been successfully attacked as yet based on that. Self-incrimination. This consists of two parts in the Charter, Section 11C and Section 13. Section 11C says any person charged with an offense has the right not to be compelled to be a witness in proceedings against that person in respect of the offense. Section 13 says a witness who testifies in any proceedings has the right not to have any incriminating evidence so given used to incriminate that witness in any other proceedings, except in a prosecution for perjury or for the giving of contradictory evidence. So that Section 11C protects you in the very proceeding you're charged with. It prevents the Crown from saying, hey, you get into the witness box. Section 13 protects a witness in respect of a separate proceeding later on from having what he said on the first proceeding used against him. Other than that, it's generally been said that in Canadian law there's no further or wider protection against self-incrimination. In other words, that self-incrimination has nothing to do with what takes place at the police station or the gathering of evidence prior to trial. In this respect, we diverge from the American law. Now, first issue, under the Charter, as under the previous law, it seems clear that the protection involves only testimonial protection. In other words, verbal aspect of evidence, including documents, of course. Doesn't cover things like blood samples, semen samples, spittle samples, real evidence, being in a lineup, having people look at you, that sort of thing. It's limited to testimonial protection only. One issue that is going to be decided under the Charter is the right of the accused not to testify and to what extent that can be used against him. It's always been accepted under Canadian law that while the accused has the right not to testify, and while the Crown or the judge can't mention that in a jury trial, nevertheless the jury's entitled to consider that fact, i.e., if he's innocent, why didn't he testify? On a judge-alone trial, the Crown's perfectly entitled to argue it and the judge can consider it. American doctrine, based on the privilege against self-incrimination, again said, well, if you give a man a right, you can't penalize him for exercising it. And American law, in a line of American Supreme Court cases, held that the accused has the right to have a jury instruction given, that the jury is not to use the fact that he hasn't testified against him. They cannot draw any inferences from that prejudicial to the accused. As far as I know, there's only one decision, a decision of His Honor Judge Killeen in the Ontario County Court called Regina versus Pelly, decided in June of 1983, and I don't know if it's gone on to appeal, but in which His Honor, following the American cases and the logic contained therein, held to the same effect and accordingly instructed a jury to that effect. Another issue of self-incrimination is the business of being charged separately. You may or may not know that the Crown will, where there's weakness in their prosecution, will charge accused who are jointly responsible for a crime in separate informations, in separate court proceedings in effect, so they can call each against the other as a witness. And again, the argument is that that violates the privilege against self-incrimination because although the accused evidence, a particular accused evidence, isn't being used to incriminate him in that proceeding, the Crown is getting all this information and thereby, if you like, indirectly incriminating him. Courts have never, none of the decisions as yet have accepted that argument or recognize that kind of jeopardy. Section 13 provides an automatic protection against future incrimination and thereby improves on Section 5 of the Canada Evidence Act, which is the present provision, but which requires a witness to claim the protection. However, I think you're making a mistake if you don't claim the Section 5 protection in addition to the charter protection for the following reason, that the charter protection is narrower than the protection you get under Section 5 of the Canada Evidence Act. First of all, if you're going to lie or say something different, the Canada Evidence Act protection is only torn away in a perjury prosecution for the giving of that evidence. In other words, the evidence under Section 5 protection. The charter protection is ripped away in any perjury prosecution, so that if the Crown was alleging you perjured yourself on some other occasion, they could use the evidence given under Section 5 in that perjury prosecution. They can't do that under Section 5. Secondly, the charter protection is ripped away on a prosecution for giving contradictory evidence. The Section 5 protection is not. But more important, and this may be an unfortunate limitation in the charter protection is worded as follows, that he has a right not to have any incriminating evidence so given used against him. The Section 5 wording doesn't have that magic word incriminating. The Crown is going to argue, and has argued in their literature, that therefore the charter protection only protects evidence that is incriminating when given. For example, a denial, I didn't do it, which only becomes, or I wasn't there, or I don't know that man, which only becomes criminating subsequently because the Crown can show that it's not true. I know our Attorney General's office will argue that is not protected by the Charter because it wasn't incriminating evidence at the time it was given. It was exculpatory evidence. For those reasons, it certainly remains my practice to continue to claim the Section 5 protection, notwithstanding the application of the Charter. I think I'll leave out certain matters of detail that will be referred to in the material and go to Section 24, the Charter Remedies, and just conclude on that note. As you know, I won't read the section, it's a long section. There are two of them. Subsection 1 is the General Remedies section. Subsection 2 is important for our purposes because it is a tremendous amendment to the law of evidence. It says that where a court concludes that evidence was obtained in a manner that infringed or denied any rights guaranteed under the Charter, the evidence shall be excluded if it is established that having regard to all the circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. As far as the Charter goes, then, this is the res discretion that the courts refuse to recognize as a matter of common law. Two important issues under this section. First of all, the relationship between subsection 1 and 2. And this arose because of a Saskatchewan Court of Appeal decision, also an impaired driving case, which has gone on to Ottawa, which says that there's a discretion to exclude evidence not only under subsection 2, but also under subsection 1. This kind of caught everybody by surprise. But the argument went this way, that subsection 2 is where the evidence must be excluded. But under subsection 1, it's a matter of the court's discretion whether to exclude the evidence. As I say, that holding has gone on to the Supreme Court of Canada. The other important issue, of course, is what does it mean bring the administration of justice into disrepute? This is obviously a violent battleground. Courts trying to define it or leave it undefined according to their personal philosophies of whether an exclusionary rule is a good or bad thing. I would like to give you Justice McKinnon's words from the Mannanen case, because, as I say, they're sort of music to my ears. What his lordship said in that case, after referring to 24.2, he said, The wording of the subsection places the burden on the appellant of establishing that the administration of evidence in the proceedings would bring the administration of justice into disrepute. I stop there and pause to note, this is not a general exclusionary rule. You have to show a charter breach first. Let me emphasize that. There's not a general discretion given in the law of evidence. You first have to show a breach of the charter. Then he went on, although this may not be a very heavy burden depending on the circumstances, I do not believe there is any area of discretion left to the court under the subsection. If the court is satisfied, then it shall be excluded. Having said that, I must acknowledge that realistically the subjective view of the judge assessing the circumstances may obviously in many cases play a part in the ultimate determination of the question. However, the court does not and cannot approach it as a matter of discretion. And as far as he goes in the particular case, he says, the breach of the appellant's rights can only be described as willful and deliberate. I would pause to point out that all the police were doing there is what they'd been doing for 100 years. Please don't get the idea that these were any exceptional circumstances. What went on here is what went on in police stations across the country for decades. But this is how his lordship describes it. It was more than a mere blunder or technical transgression. Having carefully read the appellant his rights twice and heard him express his desire to exercise those rights, the police immediately proceeded to question him as if the reading and the exercise had never taken place. In view of the open and flagrant disregard of his rights without any justification being attempted or available, to allow his answers to be admitted into evidence would bring the administration of justice into disrepute. To exclude the evidence under Section 24(2) is the only meaningful sanction in this case if the exercise of the appellant's rights is not to become an empty one. In conclusion, then, the Charter will impact on all facets of the administration of justice, and its existence makes the years ahead undoubtedly exciting times for those who practice at the criminal bar. The foregoing outline of the Charter's impact on the law of evidence in criminal cases offers clear example of the important issues still to be finally settled. Thank you.